And I want to begin by sort of giving you a thumbnail sketch of what my project is. I then want to spend some time situating it at the intersection of both sort of labor law and social change learning. And then I want to talk a little bit about what I found so far. And I want to give a caveat at the beginning, which is that I'm not done yet. So I'm going to so this is where I tell you that you know this is inevitable disappointment, and I'm going to say this is a work in progress, and so I welcome your feedback. But so I'm going to offer some of my preliminary findings and thoughts about the research that I've conducted, and I'm really eager to engage in the conversation. So just a little bit about the background, if you can read the white text here. As a very, very formal matter, the project aims to look at sort of across pivotal low-wage worker advocacy campaigns of the past decade in LA and ask a few different questions. So I'm really interested in how have lawyers and activists sought to harness the power of law to change the conditions of employment for low-wage workers in LA, how successful they've been, and under what conditions they've been successful. And I'm hoping to sort of be able to ask and answer the question of, are we able to identify, isolate factors that might predict success across these different campaigns? So what sort of background factors related to the tactics that are used and perhaps the organizational structures that are involved might be able to tell us when these campaigns are more likely to be successful than not. I'm looking at 4 campaigns, so sort of pivotal campaigns, all of which have occurred outside the domain of traditional union organizing, and which I've selected from 2 different hemispheres of worker activism. On the one side are campaigns that are focused on, and in most cases, led by immigrant workers, and that are organized around specific industry clusters. So this really builds upon the really important work of Ruth Milkman, Joshua Bloom, and Victor Nara, who published a great book on low-wage worker immigrant organizing campaigns. And I want to focus on the way that law has been crucial to these efforts as a strategic tool, and how to assess the impact of the efforts. On the other side are a set of campaigns that really come from a different domain. They come from the sort of community labor coalition domain and have been run primarily by the Los Angeles Alliance for a New Economy around specific policy goals related to different sectors of the low-wage economy. So these, for the most part, are, again, very different kinds of campaigns than the immigrant worker campaigns. I think they're run much more from the top down, and they're focused in some respects on more traditional union goals, particularly taking wages out of competition in specific industries. And we can come back to talk about those distinctions in those campaigns in the Q&A if you'd like. And just as sort of a methodological note, I'm sort of, this is qualitative research, I'm interviewing people that are key actors within the movement. I'm looking at other sources and developing thick case studies. So as all of this initial framing suggests, this turns out, I think, to be a project about labor organizing that started and still is, in really important respects, a project on social change learning, about which I study and teach, as Chris suggested, at the law school. So just as a little bit of additional context for the project, I wanted to tell you that for the past several years, I've taught a seminar on social change lawyering in our public interest program, which has featured many people that I'm sure have come through this colloquia, and which is designed around studies of actual campaigns, typically in Los Angeles. So the goal of the class is to show the students that there are many ways to advocate for different kinds of social policy reform goals, not just going to court, but also engaging as lawyers in collaboration with organizers, in public education campaigns, and in media strategy. And so in my search for really good case studies for the class, it turned out that all the best stuff ended up being right here in Los Angeles, and a lot of it came out of this really dynamic arena of low-wage worker organizing. So I started to wonder why this was so, and it turns out that the answer, or at least what I think the answer is, lies in sort of the interesting parallel historical paths, in some ways, of labor and public interest law in the post-civil rights era that I want to sketch out a little bit here. So on the labor side, there's sort of a standard story of the decline of unionism over the past 50 years that is quite complicated. It has to do with change in economic conditions, a shift from manufacturing to service, and changes within the structures of unions themselves. But it also is fundamentally a story about changes in the law. And so we can think about a set of a sort of basic post-war framework of the legal regulation of work that rests upon a set of building blocks, if you will, that permitted the development of relatively strong unions and relatively high working standards even outside of unions. And so here are these building blocks. So one was relatively high barriers to trade, which protected internal manufacturing industries in particular, which were the sites of major union success. a functioning federal labor law, by which I mean the National Labor Relations Act, which was used by unions to win union representation across industries and negotiate collective bargaining agreements. An immigration system that was by no means fair and equitable, but was up until the 1980s at least not associated with really high levels of undocumented immigration. A relatively integrated system of production, which meant large-scale industrial enterprises, like in the auto industry, with single employer workforces that could be organized, and a system of employment law rights, primarily minimum wage and overtime laws, that, again, while no means perfectly enforced, were aided in their enforcement by the presence of unions that mandated higher standards and that were enforced through grievance processes. So the picture is sort of a somewhat stable, although always contested set of legal components, building blocks, if you will, that sort of facilitated unionization and sort of stable labor relations to some degree. And this began to, in the 1970s and sort of accelerating in the 80s and 90s, really began to crumble and be replaced by a distinct legal foundation that facilitated the expansion of low-wage work. So the move was from trade protection to free trade, which undercut domestic manufacturing through outsourcing, from a functioning to really a non-functioning federal labor law system, in particular the really well-documented failure of the federal labor law system to provide a meaningful opportunity for worker organizing, primarily due to inadequate remedies for employer violations in the union election process. So almost all of the current union organizing campaigns occur outside the ambit of formal NLRA-sponsored labor law. So there's a move, again, to an immigration regime that is characterized by really high levels of undocumented immigration, particularly from Mexico, from integrated work to outsourced work, so not just to other countries and not just in manufacturing, but also in the service sector, through subcontracting and other legal relationships that insulated employers from legal responsibility for their workers. And this contributed to, at least in some sectors, like the garment sector, the systematic violation of basic employment rights, in a context where individual workers, because of their vulnerability, were really loath to assert their legal rights, and the government lacked the capacity and the will to actually enforce them and fill the void. So this contemporary system for regulating work produced a number of responses at a variety of different levels. So calls for trade pacts, international trade pacts with labor standards at the global level, and consistent calls continuing up to the present day for labor law reform at the federal level. But it also, I think, very prominently produces sort of hydraulic force, pushing labor activism down to the local level to try to respond to these changes by challenging the practices that were generating and abusing low-wage workers. And this new local challenge, I suggest, was fundamentally a legal challenge, so that the activism at the local level was fundamentally a legal challenge that focused on an attempt to reconstitute the earlier framework that I've just pointed to, but on different terms. So I think one thing that's worth emphasizing here with respect to the local approach is that it bracketed, and in some ways it assumed as a given, the sort of global and federal shifts around free trade and labor law. So it didn't contest it. The local activism wasn't directly contesting those issues, although clearly organized labor in general more broadly was. And so it sort of bracketed these global and federal shifts and tried to reformulate labor regulation on three new grounds. So one was around illegal immigration, and here the move was organizing immigrant workers and asserting their employment rights even if they were undocumented. So there's a sort of a big emphasis on that as a strategy. With respect to the outsourced work point, the move was to sort of try to reconstitute the fractured system of legal accountability through new frameworks, such as arguing for an expansion of the federal employment law liability beyond the direct legal employer, or creating new legislative or contractual arrangements that would impute liability to actors with legal control. So not just looking at the formal contractual relationship that was organized around subcontracting, but really trying to make legal liability follow economic power. Okay, so that was another strategy. And the third strategy was really to try to enhance direct legal enforcement of employment rights in the absence of other resources, both as an end, I think the important point is both as an end in itself, but also as a means to other ends, specifically worker organizing, which I'll come back to talk about in a moment. So the